What are we going to talk about? We're going to tell you what we think HR teams need to know about data protection in 2021. My name's Tony Haddon. I'm the head of the employment and immigration team here at Brodie's, and I'm absolutely delighted to be joined by Martin Sloan, who is one of our partners in our commercial services team, who has a real specialism in information law and data protection in particular. And not only that, but Martin is also the data protection officer for Brodie's. So we have the benefit of his expertise, both as a leading information and data protection lawyer, but also as someone who is at the sharp end of dealing with data protection issues for our own organization. So welcome to Martin, and welcome to everyone else. In terms of what we're going to talk about, I'm going to give you an introduction. If you're the sort of person who likes lists, you can tick that bit off the list because we've just done it. Martin is then going to talk us through the data protection landscape post GDPR, the General Data Protection Regulation being the European law, the new UK Data Protection Act 2018, and also Brexit. And he has promised me that he is going to, in easy to understand terms, explain to us all what law currently applies to data protection in the UK. So that is our exciting first step. Once we know what law applies, I'll come back in and talk to you a little bit about what we think we should be saying about data protection in our contracts of employment, together with a picture of dinosaurs. I will also then talk to you a bit about privacy notices. If you don't know what those are, the chances are you are going to need to pay some close attention to everything we say. If you do know what those are, then I'll also tell you why I think they're very important for HR teams. I'll then continue to talk a bit about data protection policies and why you should have one. And then Martin will come back in to talk a little bit about HR data more generally, and why it's important for HR teams to understand what data they have and where it goes. Martin will talk a bit about DSARs, data subject access requests. I'm sure many, probably all of you, have at some point had to deal with a DSAR. Martin will talk us through some of the latest thinking on how to respond to those. And then as our final kind of named topic, I will jump back in just quickly at the end to let you know about our thoughts on how you deal with data protection issues in settlement agreements. So if you're resolving a dispute with an employee, what should and can you say about data protection in those? Hopefully we'll also leave some time for questions at the end. So that is the plan. And without further ado, I will hand over to Martin to make the law simple.
Thanks, Tony, and good afternoon. And I should just say, although Tony has outed me as the Brodie's Data Protection Officer, that's not an invite to submit a DSAR to find out how we handle them, please. That would just add very much to my second job. Okay, so in terms of what law currently applies, as you'll all know, the UK was obviously part of the EU until we left the EU at the end of January last year, and then we had the post-Brexit transition period. So what happened at the end of December last year is that effectively what was EU data protection law became part of UK domestic law. So we have the Data Protection Act 2018, which was passed to introduce various implementing measures into UK law and came alongside GDPR. But what's happened is that bit of legislation has been amended to make various consequential amendments. And under the Brexit legislation, the GDPR, along with all other EU regulations, now forms part of UK domestic law. And there are various amendments made to that. The majority of them are fairly consequential in terms of replacing references to the European Commission or the European Data Protection Board with an equivalent UK body. But what we now have is something which is called in UK law, UK GDPR. So easy to remember, we've got UK GDPR for the UK and then GDPR, which still applies to entities that are within the EU or subject to EU law. Now, as part of the Brexit legislation as well, any EU case law that had predates the end of the transition period, adequacy decisions of the European Commission and guidance and all that kind of stuff, as it was at the end of December, effectively was crystallised and now forms part of UK law, though that may change in the future. The UK courts may decide to go in a different direction. The UK government may make different adequacy decisions, but the basic thing to remember is anything that you knew about or you're aware of in terms of EU law before the end of December still applies in the UK. So all those adequacy decisions that we had, all the cases we had, you can continue to rely upon as is. But the important thing to remember is that UK data protection law applies to anyone established in the UK, but there are extraterritorial provisions in GDPR and UK GDPR that mean they apply to people who might be outside that area. So what that means in practice is that if you are monitoring individuals, say in the EU, or providing goods or services to them, then you may still be subject to GDPR, even though you are in the UK. So it can be a little bit confusing trying to work out which set of laws apply. Potentially you're covered by both of them. And I think in the employment context, that's particularly relevant in relation to things like monitoring. So if you have systems monitoring within your organization and you are established or you have group companies in different parts of the world, then you may find that actually you are geo-regulated. And the other thing to be aware of is that in terms of intra-group processing arrangements, so say you have a parent company that provides, say, an HR system or a payroll system to an EU group entity, then if that EU group entity is a controller for its employees, then the UK entity may be subject to EU law in relation to what it does as a processor. So it gets quite confusing. I think it's probably my takeaway here. So what I would say is if you are in a business where you have different entities in different parts of the UK and the EU, it's really important to understand what processing is regulated by what regime. And you may well find that you are what we call geo-regulated, so covered by both bits of legislation in relation to different activities. And that then impacts on things like your record keeping, because you need to know what processing is covered by each regime, and things like regulatory guidance. So we may find, for example, the ICO in the UK takes a different view on something to the regulators in the EU, and you then have to try and reconcile those two views or potentially case law to work out how they apply to how you handle your processing. So I say if you are in an entity where you have subsidiaries or sister entities in the EU or the EA, then it's really important to work out what data has been processed and what regime applies to that. And then the final point, just in supervisory authorities. So by supervisory authorities, I mean regulators like the ICO. Again, because you potentially have dual regulation, that may mean that you find that your UK entity may well be subject to regulatory oversight or have to answer to a regulator in another part of the EU. So whether that's CNIL in France or one of the maybe German regulators or Italy, whatever it is, you need to understand which regulators have an interest, particularly going back to that point around intergroup processing, where say you may have a centralized IT or HR function providing services to other parts of the group. Really important just to know who's doing what, and for example, if you have a data breach, who you need to tell, because it might not just be the information commissioner, it might be a regulator in another country. And that is a change of the law in a hopefully a one-page summary.
Thank you very much. We promised to tell you what we thought you should say about data protection in your contracts of employment, and I promised you a picture of dinosaurs. So there is the picture of the dinosaurs. Why have I put that up there? Mainly to say that the old world has gone. Those of us on the call who have been working in the HR space for a bit longer will remember that employment contracts used to have a data protection clause, and it used to contain a consent by the employee to the processing by the employer of their personal data, and we kind of relied on that and didn't necessarily think about data protection a huge amount more. We can't do that anymore. Not only can we not do that anymore, but the consent, if indeed it ever was a consent, that was contained in that old contract is not valid in this brave new world that we have now entered, and which I'm representing with some sort of picture of an Oculus, or which is probably already slightly not futuristic enough, but that second picture is supposed to represent the future world. And it's really to get across that consent is no longer a realistic ground for processing most employment data. Other grounds of processing are available, So the need to perform the obligations of an employment contract, a separate legal obligation or a legitimate interest. Those are all the grounds that those of us who've worked through privacy notices, which I'll come on to talk about, will be familiar with. There is a slight caveat to that in relation to what we used to call sensitive personal data, so special category data, particularly for us working in the HR field, health data. There can be occasions where it may be appropriate to use consent as the basis of processing health data, particularly if it is data that's not required for the employment relationship. So, but most health data, so if you're looking at a disability issue, a performance issue, a capability issue, that will be processed not on the basis of consent, but on the basis of one of the other grounds. The main issue that this throws up in relation to the contracts of employment is that we use them now to signpost employees towards information about the data that we as employers are gathering and processing and using about them. So the employment contract now becomes a signpost towards other documents that tell the employees what we do with their data. And we say a little bit more about that on the next slide, which leads us into privacy notices. So in your employment contract, you're probably going to say further information about the way we process your personal data is contained in the employee privacy notice. And hopefully most of you on the call are familiar with privacy notices. They're a kind of shorthand description dreamed up by information lawyers like Martin. They're not a kind of technical term, but they've become a shorthand for the main way that organizations, not just HR departments, but also many consumer organizations, tell us what they do with the data that they're gathering about us. And privacy notices in the HR world are the main way that UK organizations will tell employees or workers or applicants for roles about the processing of their personal data. And GDPR and all that good law that Martin talked about tells us that there are certain things that we have to include in our privacy notices. So if you have a privacy notice in your organization, worth just making sure that the following mandatory information is in there. So the legal contact details for your organization, that's so that people can exert their legal rights if they need to. The identity of the data protection officer, the DPO, if you have one. Not every organization will have to have one, but if you are an organization that has to have one, then you need to tell people who that is in the privacy notice. You also then, and this is where it starts becoming more complicated for HR departments, you have to describe the types of data that's being processed. You have to describe the source of that data, and then you have to describe the grounds upon which you're processing it. So what's the justification for you processing that data? You should also tell people how long the data is stored for. Although often people cross-refer into a data retention policy or another policy for that. You also need to tell them about any use of automated decision making and then any transfers outside the UK, or if you're one of these dual regulated businesses outside the EU/EEA, if you're regulated by European GDPR as well as UK GDPR. And Martin's going to talk a little bit more about transfers and some of the issues that that throws up for HR teams later in the talk. You also have to tell people about their rights, and that includes their right to complain to the Information Commissioner. The main right that we come across as HR professionals, I think, is the right to data subject access. So the right to say, I want to see what you hold on me, give me a copy, please. And that often is a parasitic right that's exercised by employees on top of an existing dispute. So we often see data protection through the prism of an existing employment dispute, and that can cause some issues. Martin will talk a little bit more about the latest thinking on DSARs later. The key point about privacy notices and all this information that has to be given to people is that you have to give that information to the data subject at the point at which you're processing the data. And for that reason, some organizations have separate privacy notices for different stages of the recruitment life cycle or the employment life cycle. So some people will have a separate recruitment privacy notice that they can hand out to people at the application stage. And the reason why that's different to their worker or employment privacy notice is because quite a lot of the information that you have about employees, you may not have about applicants. And quite a lot of the places that you might send data for employees or workers, you may not send for people who just apply to you. So sometimes it's quite useful to have two different notices so that you're not giving people too many caveats in one big notice. Why should HR care about this privacy notice stuff? Well, A, because it's your legal obligation to explain to people what your organization does with their data, but B, because data protection is becoming more and more important, both in terms of the fines and penalties that can be applied to organizations by the relevant authorities, but also because employees, workers, and applicants are all becoming much more familiar with data protection rights. If you have not dealt with a DSAR yet, I will make a prediction that within the next 24 months, you will deal with one. They are growing in volume, and I think most organizations will have dealt with at least one by now. And in terms of responding to a DSAR, again, there are quite a lot of technical parts of the response to the DSAR beyond just giving people access to a copy of their information. And if you've got a well-drafted, up-to-date privacy notice, that's a really great head start in A, responding to the DSAR, but B, demonstrating to the authorities that your organization is aware of data protection and takes it seriously. If you don't even have a privacy notice, you're kind of on the back foot, both when responding to the DSAR and if the ICO asks you for any information. Should you have a data protection policy in addition to your privacy notices? Yes. I would love that to be the end of the story, but this is a webinar and I'm a lawyer, so I will explain why I say yes. You don't need to have one, it's not an obligation, but just like having a good IT policy or a good expenses policy, data is a key part of absolutely every employee's role, and your data protection policy should be a guide for your employees and anyone else who works in or with your organization, contractors, agency workers, and others who come in, to set out what your organization's expectations are when dealing with data. I've put on that slide a couple of things that we would expect a good data protection policy to cover. Things like when your organization expects a data protection impact assessment, how and when you're allowed to transfer personal data outside your organization, what to do if there's a data breach, who to report it to, and ultimately, as with all good HR policies, what are the sanctions for people who don't adhere to it? And that's in order that you can demonstrate to the authorities that you have data protection standards within your organization and that you police them. Martin.
Thanks, Tony. Yeah, so I'm going to talk for a couple of minutes now about why you need to know where your HR data goes, or where, and why that's important. So when I say where does it go, I'm not just talking about the geographic location, but also you need to know the entity that's processing as well. So one of the additional things you need to have in your privacy notice is you need to explain to people where their data is being shared with. So that might be your service providers. So if you use HR payroll system or something else to manage your HR records, then you'll need to know about that and explain that to individuals, but also think about the wider processing of HR data within your organization. It may not just be within the HR department, but there'll be other data as well that people, other systems that people use in their day-to-day work. So we need to be able to explain that. Secondly, I touched on this in the first bit of my talk today, intragroup sharing. So if you're part of a corporate group, then it may well be that certain information is shared with your parent company. So that might be performance information, salary information, information about absences, all that kind of stuff. And that needs to be explained to individuals. Now, that may well be on a what we call a controller-to-controller basis rather than controller-to-processor. So the recipient may be a controller for purposes of data protection law and therefore accountable for what it does, but we still need to explain that to individuals and know what's going on. And then the last category here is kind of a sweeper for other things. So remember, you will share HR data with pension providers, with occupational health providers, a whole load of other people may get access to HR data in relation to their interactions with your employees. So we need to think about that too and make sure that's all properly explained. Why do we need to do that? Well, the law requires you to know about it. So you have an obligation under data protection law to be able to demonstrate accountability and know where your data is, who's accessing it, and what's being done with it. You might need to deal with that in your contracts with third parties. So if you have a contract with a service provider, you'll need to know what data is being shared under that. You need to have some internal knowledge or database of all your data processing arrangements, so you know where your data is. You need to be able to tell people about your privacy notice. If you don't know what you have, you can't tell them about it. And then the final point, this is the one that's causing some particular issues just now, is that there are specific rules under UK data protection law in relation to transfers outside the UK and under GDPR in relation to transfers outside the EU or EEA. Now, the broad rule is that you can't transfer data outside the relevant territory unless you satisfy one of a number of hoops. So there is something called adequacy decisions, where the European Commission has determined that 13 countries or territories around the world provide an adequate level of protection of personal data, and you can freely transfer to those. We are currently in a situation where we're waiting for the Commission to make a final decision on whether EU entities can transfer to the UK. That is going through the various approval processes at the moment. We've seen the draft and it looks like that will happen, which is good. There are other countries around the world as well. In relation to transfers from the UK to the EU and EEA, the UK government has already said that they consider the EU and EEA to be adequate. So if you have to transfer data to a parent company, say in France or whatever, then that is okay. You can do that. You still need to explain it to people in your privacy notice, but you don't need to go through any additional hoops. If there's not a finding of adequacy, then you need to look at what other appropriate safeguards can be used. So with that, we use something called standard contractual clauses, which you may have heard of, which are template clauses, or binding corporate rules if you're a corporate entity and you've got some internal rules approved by the regulator. Standard contractual clauses are pretty common and they're used for the vast majority of these transfers, but there was a court case in the European Court of Justice last summer called Schrems 2, which you may have heard about, which said if you want to use standard contractual clauses, then that's fine, but you've got to assess whether that transfer is still lawful. So by that, you need to look at whether the destination territory contains laws which allow, say, intelligence agencies to access data in a way that's contrary to the principles set out in EU law. And so that's causing a particular issue with transfers of data, particularly from the EU or the UK to the US. So this case, Schrems 2, was all about transfers that Facebook was making to the US and the surveillance powers that people like the NSA have under US law. But it's not just about the US, it's about other countries as well. So if you are you're part of a corporate group where you're sharing data with another entity in another country outside the UK or the EU, or you're using a service provider where the data is hosted there, you'll want to do some diligence and understand what's being done and work out what steps you need to take. It is not an easy thing to deal with. We are still waiting for clear regulatory guidance on this, but the initial guidance from the European Data Protection Board, which was published last November when the ITO was still part of that, takes a fairly hard line on a lot of this stuff. So things like databases which can be accessed by different group entities around the world, that may potentially be an issue if you have someone outside the EU or UK who's subject to these laws and potentially doesn't provide an adequate level of protection to EU originating data. So we're working with a number of clients now trying to actually work out how they deal with this using things like geofencing or controls and restrictions to try and adjust how they handle data within their organization or with their service providers to find a solution for that. We can share in the follow-up to this a summary to a blog post that kind of sets all this out in a bit more detail, but certainly one to look out for if you are doing transfers. Okay, and so the final bit from me, just a little bit about data subject access requests. So just talking about, so I think one of the big challenges we are seeing organizations having to deal with is how they deal with very large volumes of data, which is the inevitable consequence of the fact that we're all creating, generating, and holding far more data than we ever did. So one of the common questions is, can you ask the applicant to clarify or narrow the request? Well, the answer to that is you can ask them to clarify the request, but you can't require them to narrow it. You can ask them to do it, but they don't need to do that. So if you get a request that's very broad, you can ask them if they can tell you exactly what they're looking for and for information to help you find that, but you can't require them to narrow it. And the ICO's guidance on time limits for responding now says that if you do decide to try and clarify a request, that doesn't stop the clock. The clock keeps on ticking while you're doing that process. As I say, while you can't require them to narrow, if you can't find the data they're looking for, the information you're looking for, you can ask them to provide some more information about how you can find that. So that might be, particular date periods or particular individuals or a particular matter or whatever. If they don't provide that, then you still have to respond. But do remember that your requirement is only to carry out reasonable searches. So if you haven't got enough information to actually carry out a reasonable search, then you may be justified in taking your own view in terms of what is reasonable based on the information or lack of information you've got for what the individual is looking for. And one of the things that we would always recommend in that situation is when you acknowledge the request, is actually explaining your proposed approach and saying, this is how we're going to handle this in terms of the searches that we will do. So you're telling the individual how you're going to respond to it, and then put the onus on them to tell you if actually that's not covering what they're looking for. Final point is our magic tool we can use to help. This is just a wee plug for something that we've launched recently, Brody's, which is a tool we're on discovered by Brody's. It's an AI-based tool which you can use to review and analyze documents, and we've used a number of subject access requests, and it's a really powerful tool to help you actually take large volumes of data, remove duplicates from that. So you may find your IT search comes up with the same thing 5 or 6 times, or you've got an email conversation where there's 20 emails backwards and forwards in that. So sifting all that down, and then helping you to manage and categorize that, so you can see, if you want to filter out emails sent to and from your in-house counsel to see where they might be privileged, you can quickly isolate them and then apply a manual review to that. You can then work out ones where you don't want to perhaps look at them in too much detail because you think they'll be low risk. You can do keyword searches, you can categorize stuff, etc., etc. There's a link on slides there to a bit more information about that. We'd be delighted to provide you with a demo to show you how it works, because certainly the clients who've used it so far have found that it really cuts down the time, 70,000 emails or whatever, down to 3,500 within a couple of hours. Really shows how much it can help with that process.
Great. Thanks, Martin. And just finally on settlement agreements, again, in the old days, we perhaps used to quite freely settle data protection claims the same way we would try to do with employment claims. So we would cover off future and unknown claims and try and draw an absolute line under the relationship between the employee who's usually departing and the organization. We don't think that in the new world that is as possible as it used to be. And so if you're using an old style settlement agreement with a kind of catch-all data protection waiver clause, probably time to have a look at that, because if you find yourself in front of the ICO or another regulator attempting to prevent people from accessing their data protection rights, that is unlikely to be viewed positively. In relation to existing disputes, we think you can settle existing disputes. We think you can ask people as part of a settlement agreement to withdraw an existing complaint or an existing claim. If it's a particularly significant part of the dispute, you might even think about allocating some of the compensation to the settlement of that data protection claim. And you can include, and most settlement agreements these days will do, a warranty that the individual has no outstanding complaint to the ICO that you don't know about, or that they won't make any complaint about issues that they are aware of or should have been aware of. A bit more difficult for so-called known unknowns, which is what lawyers always want to try to settle. So in your settlement agreements, I suspect you do try to settle known unknown claims. If we can go on to the next slide, we can sort of, I've set out there what we think the position is. We know that it's not possible to contract out of the data protection legislation. So you can't agree with someone that that legislation doesn't apply to them in the future. So any clause that tries to do that is just not lawfully active. It doesn't work. It's void. That means that you can't technically prevent a future data subject access request, because that is a right that we all have under data protection. But you can, if you're worried that that might happen, work in some language to the settlement agreement in relation to perhaps if they've lodged 3 data subject access requests already, an acknowledgement that a further access request might be unreasonable or unfounded or excessive. Those are ways around that global position that data protection law can't be contracted out of. And then the last point, just if you're in an organization which has a kind of dual role, so the individual works for you, but also is potentially or actually a customer or a data subject, if you're a public authority, then make sure that you carve out their data relationship with you as a customer or a data subject, service user or a resident or whatever it is, from any settlement agreement claims that you're trying to waive. So a slight change to where we used to be. A little bit of time for questions. We've got a few in on the Q&A tab. One interesting one about intra-EU transfers. So possibly relating to this adequacy decision, Martin, but it's maybe one if you can comment on. So somebody, they haven't given their name, but they manage contractor recruitment on behalf of a client, and they've asked about agency employees in Holland who are provided by a Dutch agency supplier, and they want to get salary information or fee information, I guess, about those agency employees in Holland. And the Dutch provider has said that they're not prepared to provide the salary data due to data protection restrictions. First question is that correct? I don't know if you've got any comments you can make on that, Martin.
Yes, I'm not sure whether the reason they're saying data protection law doesn't allow them to do it is the fact that there is a transfer from the Netherlands to the UK. If that is the driver here, then under the EU Cooperation and Trade Agreement that was signed at Christmas time, there is a transitionary period. So I mentioned that we're in the process of getting an adequacy decision from the EU. There is a period, a transitionary period, which allows transfers to continue being made up until the end of June, by which time we will hopefully have a definite answer. So if the issue is around the international transfer part of it, then there's no barrier here. If the issue is actually around the lawfulness of the transfer and whether it's necessary and therefore can be justified in data protection law, if this is information that the client needs in order to comply with its legal obligations, then that will give the Dutch agency safe harbor in terms of transferring that data to you. So there's clearly a purpose that it's necessary to transfer it for, and that should provide a justification. This isn't special category or sensitive personal data, so you don't need to look at any of the more restrictive conditions for that. So I would have thought this one is one that could be resolved with a conversation with the Dutch agency.
Brilliant. Thank you, Martin. I hope that helps. Anonymous attendee, which is what I've got as your name. It's 35 minutes past 1, and I have a pet hate of webinars that run on. So apologies for being 5 minutes over. We will get back to others who've asked the questions directly. But that concludes the session. Thank you very much for attending. I hope you found it useful. I've popped our contact details up on the screen, and we look forward to seeing you at one of Brodie's webinars again in the future.